Hello, and welcome to the second episode of our special three-part edition of Ethics Express, where we're discussing government ethics laws, principles, and practice. Here joining us to continue last episode's discussion is Mark Davies. Mark is the Executive Director of the New York City Conflicts of Interest Board and the Chair of the New York State Bar Association Municipal Law Section. In the last episode, we discussed the general purpose and history of government ethics laws. In this episode, we're going to dial into more of the details about how an ethics law is structured. So Mark, why don't you start us off? Just give us some basics of how to structure a good ethics law.
Sure. Well, first of all, any good, effective ethics law must rest upon three pillars or three legs. And if you remove any of those pillars or any of those legs, the entire structure will collapse. So you have to have all three. The first pillar is a clear and comprehensive code of ethics or conflicts of interest code. The second is disclosure, and the third is effective administration.
All right, three pillars. Let's get into more detail about those. Can you tell us more about that first pillar, the clear, comprehensive ethics code?
First of all, the ethics code must be clear, must be comprehensive, must be sensible. It has to be understandable by public servants without resort to attorneys, without calls to attorneys. Probably the most critical provisions are provisions on misuse of office, misuse of government resources for non-government purposes, confidentiality, gifts, and also revolving door post-employment restrictions, that is, some kind of prohibition on appearing before your former agency for some cooling off period, for example, 1 year, and also a prohibition on ever working on a matter that you personally and substantially worked on for your government agency.
All right, so that makes sense. We need a clear, comprehensive ethics code that even a non-attorney could understand with clear restrictions. But you're saying that that's not all that we need. Why don't you talk about that second pillar, disclosure?
Sure. The second pillar is disclosure. And there are essentially three types of disclosure. The first type is what we call transactional disclosure. That is disclosure when a potential conflict of interest actually arises. So, for example, if I work for a Department of Transportation and my brother-in-law is going to bid or might bid on a contract for the purchase of concrete, then I would have to disclose that fact to my superior and maybe to an ethics board, depending on the jurisdiction, and then would have to recuse, that is, disqualify myself from having anything to do with that contract. That's transactional disclosure. The second kind of disclosure is kind of like the flip side of transactional disclosure, which is applicant disclosure. In applicant disclosure, someone that is applying, a private citizen or company that is applying for a government contract or a government license, permit, benefit, so forth, funding, would disclose in their application the interest of any officials who might be involved with that application, who have an interest in the application or in the applicant. So that's applicant disclosure. The third kind of disclosure, which is certainly the most controversial, is what we call annual financial disclosure, whereby a certain relatively limited subset of all the public servants of the jurisdiction will disclose annually certain assets and liabilities.
So we've now discussed two pillars, the clear, comprehensive ethics code and disclosure. There's a third pillar. Can you tell us a bit about that?
Yes, the third pillar is effective administration by an independent ethics board.
Independent, you emphasize that word. Why is an independent ethics board so important?
Well, without independence, no one is going to believe that the board is in fact acting in the interest of the public and not in the interest of those to whom they are dependent, on whom they are dependent. So an independent ethics board is absolutely critical.
Okay, you've convinced me we need an independent board, but how will I know one when I see one? What are the indicators I could rely on in determining whether a board is truly independent?
There are a number of indicators of an independent ethics board. One is in the appointment process. They should be appointed by ordinarily the chief executive officer with the advice and consent of the legislative body. There should not be multiple appointing authorities because that generates factions. It results in disclosures in violation of confidentiality. The board members tend to then become almost like surrogates for their appointing authority. So it's a single appointing authority, but with the advice and consent of the legislative body to ensure balance of power. That's one really critical point. They, of course, should be essentially volunteers. Their income should not be dependent upon this ethics board. They should be removable only for cause after a hearing. They should not be employees otherwise of that government, because if they are, it's like having a mole on the board that here's someone that's going to rat out public servants' requests or complaints to perhaps their superiors or supervisors. So that's really important. So those are some of the most critical indicators for an independent ethics board. And then one final one I'll mention is budget. There should be a protected budget. Without a protected budget, an ethics board can simply be gutted by the powers in that government at any time.
All right, so you've given us a lot of food for thought in terms of how to ensure that an ethics agency is truly independent. But now I'm more curious about what the ethics agency will actually do. I think that would be a great topic for us to discuss next time, so we'll do exactly that. We'll see you then.